All right, everyone. Thanks so much for joining Jenna and I today. Good morning, Jenna. Good morning, everyone else. Jenna is a wonderful employment law attorney who I've known for quite a while, and so she was kind enough to partner up with me and talk today about some of the big compliance things you need to be focused on. And I'm here, of course, to talk about culture and some of the sort of more HRE types of things. So we're going to introduce ourselves and just a couple housekeeping items before we jump in. The question box where you all typed in, yes, you could hear me and all of that kind of thing, please feel free to use that very actively. We are very interactive webinar deliverers, so we'll be happy to sort of answer questions along the way if it makes sense in the moment to do that. Also, continue to type in questions all along the way and up until the end. So Jenna and I plan to give just over an hour of sort of webinar content, and then we figured there would be a lot of questions, so we'll do some sort of free Q&A there at the end as well. So when all is said and done, we expect we'll be here for about 90 minutes, maybe a little bit less, but definitely use that questions box all along the way. So I'm Katherine Sandell. I am the CEO and founder of Civility Partners. Civility Partners is a full service HR consulting firm ranging from services down to doing a one-time employment handbook or corporate policy handbook, all the way up to big culture change processes where we'll partner with clients for 2 or 3 years even to help them create a new type of culture. So right now, my big concern as a culture consultant is the damage that's being done to all of our cultures, given that everybody's operating in high stress mode and that we're working remote and we're all in the unknown right now. So culture is something that's important to me that we keep track of. Jenna, I'll let you introduce yourself and then we'll jump right in.
Thanks, Catherine. Hi, everyone. I'm Jenna Jones with Leighton Jones Law. I'm an employment law attorney, and my focus really is on the preventative side of employment law. So I help employers with all of the day-to-day employee issues that arise. Obviously, now with everyone trying to figure out, what to do with their businesses, what to do with their employees. Do they need to lay off people? If so, how do they do that? Do they need to be providing paid sick leave or other types of leave? So those are the types of issues that I help employers with, along with all of the other normal day-to-day employment issues and stuff that arises. I also help employers with drafting policies, procedures, handbooks. I provide employee training, and I also conduct workplace investigations. So I am happy to be here today.
Cool. All right, Jenna and I agreed that we're going to actually turn our webcams off because it helps with the streaming. So you will not be able to see us, and then we'll pop back on during the Q&A period, but I didn't want anybody to think their computer had exploded. The streaming works a little bit better. It takes up less bandwidth. So you can't see us anymore, but here we go.
All right. So obviously there are a lot of considerations that business owners have on their plates right now. And in the limited amount of time we have today, we're obviously not going to be able to talk about all of the employee issues that you may need to consider either now or sometime in the relatively near future. So my goal today really is just to give you sort of a macro level overview of some of the biggest issues that business owners should be thinking about in terms of their employees. Now, regardless of the specific topics that I'm going to discuss today, you should ensure that you are complying, obviously to the extent possible, with all of your normal responsibilities as an employer, particularly in the wage and hour arena. Unfortunately, there are many plaintiffs' attorneys out there just waiting for employers to slip up with respect to their many obligations during this chaotic time, which they can then capitalize on weeks or months down the road by bringing a claim. And unfortunately, during times of economic downturn and economic crisis, we tend to see current and former employees looking for ways to buffer or cushion their financial hardship. And they do this in part by consulting with plaintiffs' attorneys and by bringing claims. And while it's probably difficult to 100% insulate yourself and your business from this type of threat, you really can and should try to eliminate as much risk as possible by ensuring that you are dotting your I's and crossing your T's when it comes to your obligations as an employer. Now, kind of going back to the specific things that you should be thinking about in terms of the COVID-19 crisis, On a macro level, there are three kind of basic things that employers should currently be doing. And I'm going to give you kind of the overview, and then we'll go into more detail as we go through the presentation. But the three things that you should be kind of doing on a macro level right now are, number one, and hopefully you've already done this, determine if your business is legally permitted to continue its operations in light of California and other states' shelter-in-place orders. Number two, if your business will be operational, make sure that you understand and comply with your legal obligations as an employer. And number three, don't panic. Use the resources available to your business. I know that's easier said than done right now with so much information kind of being thrown at us on a daily basis. It's hard to know what there is and how to use it and how to take advantage of things. But hopefully our webinar today will at least, boil down some of the things that can help you continue to thrive during this uncertain time.
Yeah, my husband and I were just talking yesterday about how there's so many resources that you could almost be overwhelmed and spend too much time on understanding the resources instead of sort of chasing the money with your clients. So there is a lot out there.
Right. So in terms of the first thing you should be doing, which is determining if your business is legally permitted to continue to operate right now. Obviously, we all know that California is currently under a shelter-in-place order that, as of right now, has no definitive end date. That shelter-in-place order states that essential services or critical infrastructure sectors are permitted to remain operational, meaning go about their normal day-to-day activities with employees at the work site. And if you're not sure if your business is part of this, essential critical infrastructure, you can go to this website that I have listed, which lays out all of the different categories of essential businesses. Now, if your business has been deemed non-essential or non-critical and is not part of this list, you have a couple of options. Either you can continue your operations remotely with your employees teleworking, or you may need to close up shop for a short period of time while the shelter-in-place order is in effect. The order does indicate that a company's minimum basic operations at the normal worksite are permitted. So these are operations that are necessary activities to either maintain the value of the business's inventory, ensure security, process payroll and employee benefits, and other types of related functions. Or there are activities that facilitate employees being able to work remotely from home. So that's sort of the state order. We've also gotten, prior to the statewide shelter-in-place order, we did have several different more local city and county orders, and it hasn't been entirely clear if the state order supersedes all of those local orders, some of which are more specific and more prohibitive than the state order. So I would say at this point, the best practice really would be to try to comply with both the state order and any local order that may be applicable to your business.
What if you find that they don't match up, Jenna? Would you consider choosing one over the other, or speaking to you maybe?
Yeah, the safest route I think is always going to be to, unfortunately for businesses, is to go with whichever order is more restrictive in terms of, trying to protect employees, trying to protect the public. Hopefully there isn't too much conflict between the state and local orders, but definitely err on the side of caution, I would say, during this uncertain time. Now, if your business is not going to be operational, meaning that you're going to have to, basically cease operations for some period of time, you want to make sure that you are complying with layoff and furlough rules if you are going to have to lay off or furlough your employees. Now, there are a lot of different sort of rules that surround layoff and payroll, but one thing that you should be aware of if you are a larger company is that you may be required to comply with what's called the Worker Adjustment and Retraining Notification Act, or WARN Act, if you are a larger employer. There's a federal version of this act, and there's also a California version of this act. The federal version only applies to employers with 100 or more employees. The California version applies to employers with 75 or more employees. But just be aware that if you are, in those number ranges in terms of your employees, you want to make sure that you are compliant. And I'm not going to go through all of the minutia of the requirements. I'm happy to do that offline if anybody has questions, but I just wanted to let everybody know that with respect to California's WARN Act, Governor Newsom has suspended employers' obligation to provide 60 days of advance notice of a mass layoff, a relocation, or a termination. Normally, the requirement is that a company give employees 60 days of notice. Obviously, with what we're going through right now, that notice period is not possible for a lot of businesses. So that requirement is suspended. However, California employers subject to the act still have to provide notice to certain agencies like the Employment Development Department, the local workforce investment board, and the chief elected official of each city and county government within which the termination, relocation, or mass layoff occurs. Under the suspension of the WARN Act rules, the notice must be given as soon as practicable and provide a brief statement of the basis for reducing the notification period. Additionally, for any WARN Act notice that is given after March 17, 2020, the notice has to provide language that says if you have lost your job or been laid off temporarily, you may be eligible for unemployment insurance. And then more information on unemployment insurance and other resources is available for workers and there's a specific website that you have to provide. So that's the WARN Act. Again, that really only applies to larger employers, but if you do fall into that category, you want to make sure that you're compliant there. The other thing that all businesses need to consider if they are going to be laying off or furloughing workers is that a layoff or even a brief temporary furlough may trigger final pay requirements under California law, meaning that even if you are only planning to furlough your folks for a couple of weeks, you still may be obligated to pay them all monies owed to them on their last day of employment, which would include, obviously all of their accrued wages, but also all accrued but unused vacation time or paid time off.
Question for you. So we've got someone reminding us here that there are some national listeners here. Everyone's not all in California, though the majority of our listeners probably are. So could you speak, Jenna, to if you are not in California, where do you go to find information on the WARN Act and federally, as well as I'm assuming every state has some version of the California EDD. Could you just speak to some resources there?
Yeah, I don't have specific resources offhand, but if you just Google, federal WARN Act, WARN, you'll get, hundreds, if not thousands of websites kind of going through the act and what is required. And I'm certainly, like I said, I'm happy to talk offline with anybody who thinks that their business might be required to comply, and talk more specifically. The acts do have a lot of specific requirements, which we don't have time to get into today. But I'm happy to chat offline with anybody that wants to.
And you said it's federally, it's for 100 employees or more?
In general, yes. Although there are some various, specific rules about how you calculate how many employees you have and if they're full-time or part-time, and it gets a little bit complicated. But in general, yes. We're not talking about companies that only have 10 or 15 employees.
So bottom line is talk to you before you do anything like that.
Or talk to somebody that has experience with these laws if you have questions. Now, if your business is going to be operational, either with your employees at the work site because you're an essential business, or with employees working remotely because you're not an essential business, you want to make sure that you comply with wage and hour laws. Now, your obligations are obviously going to depend on the circumstances, whether we're talking about exempt employees or non-exempt employees or, teleworking employees. So it's all very fact-based, but a couple of important things that you should keep in mind. For those of you who are or do have your employees working remotely, just remember that at least under California law, your employees are entitled to reimbursement for all reasonable and necessary business expenses. Now, this rule isn't specific to the COVID-19 era. It's Labor Code 2802, which is applicable all the time. But now with a lot of employees working from home, there are likely going to be some additional business expenses that these employees are incurring that they normally would not if they were working at the work site. So we're talking about things like a printer if they need a printer to do their jobs. So using their personal cell phone for work now, the cost of Wi-Fi for their personal residences, the cost of any personal electronic devices they may be working on, that sort of thing.
Now, in addition to all of those expenses, there's going to be some other cultural things that they're going to face. And so I wanted to speak to those before we jump into all of the compliance stuff. Just keeping in mind that your employees are maybe experiencing some trust issues if they've gone remote because you guys all can't see what each other is doing. And so, as your resident culture consultant here, just wanted to speak on some of what your employees may be going through here. So while they need reimbursement for things like printers and other things they may be doing, they also need some attention. They need some TLC. And what's interesting is to consider that even if you're the business owner, you might be thinking, well, my employees don't need to know what I'm doing. I'm the owner. But they kind of do, when you're in the office together or on a work site together, whatever that looks like for you, your employees can see you and they know that you're doing something that's important to the business. But how do they know now that you're having them do a bunch of work and you're just kind of hanging out at home, not doing anything? So just something to keep in mind, that you really have to be transparent about what you're working on as well. It's not just, I want to know what you're doing, I'm the owner. It's got to go the other way around. And in fact, my one of my team members here, Rebecca, she's my right-hand woman and our junior consultant. A lot of times I'll maybe walk in the door when I come to work and say, hey, what are you working on today? And she'll respond, and then she'll say, well, what are you working on? And it's a fair question for her to know what I'm working on. So when we have our one-on-one calls, which we do every day, we're both sharing what it is that we're focusing on for the day. Also keep in mind that when you're engaging in remote work, that the feedback is delayed, so things aren't happening as quickly as they may be used to. So just keep in mind that it may take them a while to get back to you because now you're not able to just pop in there over to wherever they are and say, hey, what's happening here? Also consider the context. So here at work, when you're together, if somebody shoots you an email and you don't answer it for a couple hours, they can see that you're in a meeting or on the phone, or you might have verbalized on your way to the kitchen that you've got that big thing due by 2 o'clock today or what have you. But now they don't know what silence means. So consider the context of things. And I've been using this word a lot lately, meta communication, which means communicating about your communication. So now if there's email exchanges going back and forth, it might be wise to respond with, I've got some other things to do. I'll get this to you by the end of the day, or I'll get this to you by tomorrow. So that they understand why you're silent and not wondering if you got whatever it was they need. Something else to consider is isolation. Now, we've got several HR clients where their employees are feeling isolated. And in fact, I just spoke to one employee on Friday. She called to basically say, I get what I need work-wise from my manager, and all that's good, and we speak every day, but I'm feeling really anxious about everything that's going on, and I'm really concerned about my billable hours, and I'm honestly feeling a little depressed, and what do I do? And so we talked a lot about getting up in the morning and showering and going through your morning routine so that you're feeling like there's a purpose in your day as opposed to working all day in your jammies. But also this company that this employee works for, they really have not been using video conferencing at all. Everything has been over the phone. And so I told her that I really encouraged her to speak to her leader about using video conferencing. And really at this point in time, phone calls should be the exception and video conferencing should be the rule, because we are social creatures and we require connection.
Hey,
Also,
Catherine,
oh yeah, what's that?
Oh, I had a question. Catherine, have you had many clients who have done like virtual happy hours for their teams or virtual lunches?
Yes, and in fact, we also do virtual happy hours. So we're doing them every Wednesday. We're doing virtual happy hours. It's a standing meeting at 4:30, and it's kind of funny. We're actually communicating much more often with our remote workers than we were before. So it's kind of interesting how that's happened. So a couple of our clients are doing chats at lunchtime as opposed to videos. So they've got one person who's sort of in charge of posting questions, and then everybody's responding to the questions over chat. So yeah, I have been seeing that. I had a virtual happy hour yesterday with my networking group as well. So I'm seeing some other suggestions. Coffee hour, so everybody can get together with their coffee in the morning, or meditation minutes. I do see a question about furloughed work, and we will get to that, Amy, when we pop back over to Jenna speaking on compliance. So I just wanted you to know I do see your question. Um, we've been suggesting too, and I haven't done this with my team, but I may start, is just turning on your camera and working. So to sort of imitate being near each other, so that even if you're not necessarily talking to each other, you can kind of be there in silence getting your work done, but then it sort of emulates the ability to kind of comment at random, as we often do when we're working next to people. So we might start trying that here. And then also children is an issue as well, right? Some of your employees may have children at home that they're now homeschooling, and it can be difficult. I had a conversation yesterday with one of my consultants about this, and I was saying, my child is here with me. She's 6, so it's not always possible to just keep her away while I'm doing something like a webinar. You may hear her at some point today. um, Versus so I've just kind of come to this thing of like, look, she might be on a work call with me, and I just have to be okay with that, and the people at the other side have to be okay with that. But then one of my consultants yesterday was saying, well, when you speak to people who don't have children, they may be a little less tolerant of something like that because they don't understand what that's like. So I think it's important to have those conversations with your employees about managing children, and quite frankly, really, you've just got to make children being it's got to be a norm for you. All right. So in terms of productivity, some tips for you, or for you to deliver to your employees. One is to have a designated workspace. So it's important to, again, emulate getting up and going to work. So suggest that people get up, shower, go through a morning routine, and then sit down at some designated place every single day, whether it's their dining room table, or maybe they're lucky enough to have a home office. Secondly, and a tip for that is maybe you can all share photos about where you're working, just to build that connection. Secondly, creating boundaries and rituals. So one of my colleagues or friends, for example, she and her husband are both homeschooling, and so they had to create kind of a schedule for who's going to do what when. And so she, my girlfriend's responsible for creating the agenda for the day, but then she sort of assigns tasks to each of them, and that way she's got some boundaries and she can get some solid work time in, and so can he. Another suggestion for your employees is to create some rituals. So, every morning we get up, we get ready, we get in our car, and we drive somewhere, and then we walk in the door of our workplace, and our brain recognizes, kind of the switch turns on of work mode. You're lacking that now if you're working from home. So it's important to have a ritual. So maybe it's one last cup of coffee before you jump into work, or one walk around the block before you jump into work. So it's important to emulate rituals, which is something you had before all of this. Figure out a way to implement that in your regular life now. Otherwise, the days start to bleed together, right? Also consider that your employees are all operating in burnout mode, and you are too, right? We are all in super high stress, high anxiety, and that is an exhausting place to be. And every single person in the world basically is in high stress. Also, lots of research finds that people who work remotely tend to overwork because they know they cannot be seen, and they want to prove their value to their manager and prove that they are doing stuff, right? So there's two things working against you in terms of people being at home. So consider burnout, and I love the idea of meditation together, or I've been hearing of people or gyms kind of doing videos for classes, maybe a yoga class. So maybe your teams can do things like that, or you can suggest to your team that they take a half an hour to do some sort of exercise or something, but you've really got to make it known to your employees that you're concerned about burnout because they're in high stress mode right now, and that you're making room for them to relax a little bit so that they don't burn out. Another suggestion for you is to define success in outcomes rather than hours. So if you have hourly employees, a receptionist, for example, who, she clocks in or he clocks in at 8 o'clock and leaves at 5, and that's the pay. Maybe we can't really do that right now. So perhaps this person could be instead sort of measured by the outcome. So if there are projects you can give this receptionist to work on, then you can measure their productivity on whether or not the project is completed. We're doing a lot of that back end systematizing that needed to be done, but has never, we never have time because we're always working on clients. So we're in the process of working on what we're calling a playbook of processes. And that's an outcome, because I don't know how many hours people are working really. Couple more suggestions. Using a timer is a really great idea. So I actually have a cube on my desk that has numbers on it. It's like a die, but it's got 30 minutes, 15 minutes, an hour. And I just turn the die on and put it on the number I want. And that helps get through the day step by step. So it's like, I'm going to check emails for an hour, and I turn it on, and there we go. Again, being at home and in your jammies, and the days are all starting to run together, it's hard to just kind of stay on task and measure if you're being productive or not. So it's a great way to make sure things are getting done. So I'm going to work on this task for 30 minutes, and then when I'm done, I'll get up and get myself a glass of water or walk around the house for a minute. And then lastly, making sure that your employees are scheduling their breaks. They still have to take lunches, as Jenna will attest. They still need their 10-minute breaks if they're clocking in and they're hourly employees, right? So making sure that your employees are still taking the time to do that, which will also help with connecting and avoiding burnout and all of that kind of stuff. So some last tips here for making sure that you're connecting with everyone. Again, making sure that cameras are the norm. Phone calls should be the exception. You really should be connecting with each other. We are human connectors. We are, social creatures by nature. It's in our DNA. And so we need to talk to and see people. It's just part of how we function. Having those virtual lunches. So maybe especially your hourly employees in the interest of, or non-exempt employees in the interest of ensuring they take a 30-minute lunch. Perhaps everybody can clock out and you can offer up a virtual lunch. You can't require them to attend, of course, but offering that up as a way to say, hey, let's just get together and have lunch and chat and find out how everybody's doing. Showing serious appreciation. So whatever you've been doing to show appreciation before coronavirus, you've got to up your game, 50%. People need to know that you still value them, you still need them, you still want them there, because they can't see those facial expressions. They can't see you regularly. So they really need some TLC and special attention. Definitely holding frequent and consistent one-on-ones is another tip for connection. Having a call every morning at 9 a.m., for example, might be important. Now I guess this tip sort of depends on your relationship with your staff. I got to be honest, Rebecca and I, who we speak every day, we're not on a schedule. We don't speak every day at 9 o'clock, but we do speak every day. And I think she and I both recognize that we speak to each other when it makes sense to, when the project's coming to an end or something needs to happen. And so we need to connect on it. But if you're managing a lot of people, it may be important to have that predictable cadence and have that in your schedule. And then lastly, making sure that you're sharing the context. So again, remember, we cannot see each other as often as we could when we were working together on site. So something that you may have originally said before coronavirus, you might have said something like, hey, can you send me that report? Well, there's no tone in there. If it's in an email, they can't see you. They don't know what kind of mood you're in when you sent that email. So it's helpful to really provide context when you're asking for things like this. Can you get me the report? I'd like to review it so that they know what's happening. So these are my tips for building connection and helping avoid burnout. So Jenna, I will turn it back over to you for some compliance things. And actually, I do have one question about furloughed work that we'll start there. So someone's asked, what about an employer that's furloughed half of its 22 employees on March 20? Do I have to retroactively pay out all the PTO that was available?
So the Division of Labor Standards Enforcement in California has previously issued, several years ago, these aren't recent, previously issued a couple of opinion letters that indicated that if an employee is furloughed and they are given a specific return to work date within the same pay period, that they do not have to be paid out all accrued vacation and PTO. In other words, you don't have final pay obligations. But if they are furloughed without a specific return date within the pay period, then the DLSC has previously sort of taken the position that you do have final pay requirements, meaning that you are required to pay out all accrued but unused PTO. Now, like I said, unfortunately, these opinion letters are several years old. To my knowledge, we don't have any current guidance from the DLSC about whether or not these opinion letters are kind of still the DLSC's opinion on this, given, the mass furloughs and layoffs that we're currently seeing. The DLSC's opinion letters they're not considered law. They're not binding per se, but they are considered persuasive authority that the courts look at and that employers generally should try to follow. So I would say, if you've laid off people, a week or two ago and you're not sure when they're going to be returning, I think it's probably a best practice to go ahead and pay them everything that they're owed up until this point. Worst case scenario, you're able to rehire them shortly, and then, you just pick up where you left off. But I would certainly try to err on the side of caution if you can.
And I have a comment here that the local Chamber of Commerce, this is East County Chamber of Commerce is sponsoring this webinar. They certainly have some great resources, as well as the National Chamber of Commerce. I've seen some good PDFs coming out of there, as well as Cal Chamber, if you're a member and in California. So you'd find some good resources there. And someone also mentioned this morning, someone was watching the news and the traffic reporter was on with a screaming, yelling toddler in the background. So kids are the norm. And there's a funny video that was already out about somebody on like CNN, and same thing, a daughter comes in and the nanny's like ninja crawling across the floor to get the toddler out of the room. Anyway.
Yep. All right, so going back to those employee compensation and reimbursement issues, I had previously mentioned the need to reimburse employees for all reasonable and necessary business expenses. In terms of employers that are reducing hours or cutting work schedules, in terms of pay obligations, if the employee is non-exempt, generally California law doesn't require non-exempt employees to be paid when they're not performing work. But just be aware that there are some exceptions to this rule. For example, employees might be might be entitled to what's called reporting time pay if they report to work or if they're required to call into work, but they don't end up being given work for a full work day. Whether or not reporting time pay is owed is a very fact-specific analysis. So again, it's a good idea to seek some legal guidance if you're not sure what your obligations are in terms of your pay there. Situation gets a little bit more complicated and hairy with respect to exempt employees, because exempt employees are entitled to compensation for an entire work week as long as the employee performs any work during any portion of the week. So even if the employee, takes a 5-minute phone call or responds to an email for 60 seconds, that triggers the pay obligation for the full week. And that's the case even if there isn't work for them for the rest of the week, or even if the employer then says, hey, I don't want you working for the rest of the week. If they performed any work within the work week, they are entitled to their full pay for the work week. If they legitimately don't perform any work within the work week, then you don't technically have to pay them. But of course, with everybody working from home, it's really difficult to sort of control an employee performing no work, particularly, if an exempt employee has access to all of their normal, email and all that. Hard to prevent them from responding to an email or performing a minute's worth of work. And you don't want to create risk for your organization by failing to pay them when in fact you should.
So is the best practice to, now maybe I'm getting too technical here, Jenna, but is it about saying, hey, don't do any work for the week because we're trying to preserve cash, and then but then also there's the morale piece. You maybe don't want to be telling employees don't do any work, but just curious on and does that, if you tell them not to work for the week, does that trigger a little unemployment pay because they didn't work for the week and so they're not getting paid?
Yeah, you can certainly tell them, I don't want you working at all this week. That should trigger their entitlement to unemployment, at least for that week, if their hours have been reduced. However, because I think it's very risky to tell employees that and kind of expect them to comply 100%. I think that if you're in a financial position to just continue paying your exempt employees for whatever work they may or may not be doing during the week, assuming that they're still getting their work done that they need to get done, just to continue to pay them rather than, risk telling them, hey, you're not allowed to perform any work. And, they go and respond to a couple of emails or take a couple of phone calls. And then a month or, 6 months down the road, you're being hit with a DLSC wage and hour claim alleging that you failed to pay them all the wages owed because they should have been paid for that whole work week and instead they got nothing. So You can certainly, tell them don't do any work, but best practice, safest practice is just to continue, paying them. And that, of course, allows them to work as much as they want or need to.
We have a couple questions here. Hi, Elsie. Fancy meeting you here. Can they use available sick or vacation to complete a day? For example, an exempt employee works 2 hours and has vacation available. Can they use 6 hours vacation pay for the day?
So you're not allowed to dock an exempt employee's daily pay unless they are taking time off for a personal reason that's unrelated to their workload or sickness. So if they work 2 hours and then say, hey, I've decided I'm not going to work anymore today, I'm going to go find a trail that's still open and take a 7-hour jog, then yes, they can substitute PTO. But if they work 2 hours and then they have, the employer either says, hey, I don't want you doing any more work today, or there is no more available work, you cannot dock their pay for that day. So they have to be paid for the full day regardless.
Okay. And then and I'm getting a couple questions about the recording and the slides. Yes, we will send the recording out after the webinar today, and slides you'll have to make a special request and we'll send the slides to you. Okay, another question. What if any obligation do we have to our independent contractors who are impacted?
I'm not sure exactly what the question is in terms of obligation. It's my understanding that independent contractors are now eligible for unemployment benefits, at least to some extent. So to the extent that their workload or work is reduced, I think that they are now eligible for some supplementary income through unemployment. And I'm not sure if there was a more specific question there. If someone wants to ask, I'm happy to answer something more specific.
Rebecca, if you want to give us some more details on your question, we'll come back to it if you want to do that, or you can wait till the end and we can answer it then. All right.
All right, so moving on to health and travel related inquiries. As most of you probably know, under normal circumstances, employers are generally forbidden from inquiring about employees' health, as doing so could violate the Fair Employment and Housing Act in California or the Federal Americans with Disabilities Act, which generally prohibit any type of, health or disability-based discrimination and harassment. However, given the present circumstances, the Equal Employment Opportunity Commission and California's Department of Fair Employment and Housing have opined that it is permissible for employers to make certain health-related inquiries in light of this COVID-19 crisis. They're also permitted to make some travel-related inquiries. So in terms of the health-related inquiries, employers can ask employees if they're experiencing COVID-19 symptoms such as fever and chills, a cough, a sore throat. They can ask employees why they've been absent from work, if the employer suspects that it's for a medical reason. According to the Department of Fair Employment and Housing, asking why somebody didn't report to work is not one of those forbidden disability-related inquiries. Additionally, normally, standing at the door to the work site with a thermometer and taking an employee's temperature would be considered a prohibited medical examination. But based on current CDC and local public health information and guidance, employers may measure employees' body temperature for the limited purpose of evaluating the risk that the employee's presence may pose a risk to others in the workplace as a result of the pandemic. And of course, to the extent that the employer does obtain any health or medical information from an employee, they are required to keep that information confidential. If an employee does test positive for COVID-19 and the employer learns about that, they should be notifying employees who may have come into contact with that individual that they may have been exposed to the virus, but they should not disclose who has tested positive or any, personally identifying health information regarding the individual. Now, in terms of travel-related inquiries, if an employer is aware that the employee has traveled, which again, I think most people have kind of put the travel on ice for now, so I don't think this is a huge issue, but if the employer is aware that the employee has traveled, the employer can inquire about their potential exposure to the virus, even if the employee is not exhibiting any symptoms of the virus currently. And employers can also ask employees who have traveled if they visited specific locations that are considered to be hot spots like China, South Korea, Italy, and if so, to ask them to remain home for 14 days upon return. Now, I don't know, given that we're a couple weeks down the road on this, I doubt that there are many people who are currently, making those kinds of trips. And I think with the current travel restrictions, that may even be impossible. But technically, you are entitled to ask. Now, if you have an employee who seems to be exhibiting symptoms of some kind of illness, the World Health Organization, CDC, and EEOC have opined that it is permissible to instruct an employee to go home or require the employee to remain home if the employee is exhibiting symptoms of an upper respiratory illness. And of course, the employer must comply with all paid sick leave rules that may be applicable in that scenario. And if paid sick leave is exhausted, then the employee might be entitled to other, paid time off or vacation time or other types of job protected leave. So moving on to the Families First Coronavirus Response Act, which was the federal legislation that was passed a couple of weeks ago, actually goes into effect today, April 1st. Before I start talking about the nuances of this federal legislation, I'll also note that the Department of Labor has posted a frequently asked questions page on its website that it's been updating every couple of days. I think the most recent update was a few days ago, but I know I personally have been checking that website daily to see if the guidance has changed at all, because some of the guidance from the Department of Labor is actually slightly different than what the initial legislation appeared to be. So it's really a good idea for all employers to check that website at least every couple of days to see if there are any more nuances that they need to be aware of as they're trying to implement this legislation. So essentially, there are there were various parts to this bill that was signed. I'm going to talk about the two of the biggest chunks of it, which are the emergency paid sick leave portion and the emergency FMLA expansion.
Before we do that, Jenna, I want to just interrupt for a second because this question's related to the last bit of information or previous information. So this person's just looking for super clarification. So she says, I'm hearing conflicting information about whether an employer can require an exempt employee to use PTO or vacation time for hours they don't work. So if they go for that nice long jog, the employer can fill that day with PTO. Legally, which way is it? So maybe just speak to that one more time.
So yes, if they take 6 hours, 8 hours, however much time in a day off of work for a personal reason, that's not an illness related reason, but that's personal and doesn't have anything to do with the amount of work that the employer is giving them or that's available. Yes, their pay can be docked for the day and they can be allowed to fill in that time with PTO. So if they decide to go on that trail jog for 6 hours, yes, their pay can be docked, and if they want, they can use any PTO. But if they work for 2 hours and then there's no more work available, or if the employer says, hey, I just don't want you to work anymore today, they still are entitled to their pay for the full day.
So that's going to be hard to manage, bottom line, because they might say, well, I went for a jog because there wasn't much to do, but then the employer could say, well, you did have stuff to do, but you went for a jog. Sounds complicated.
I would say in general, my guidance on exempt employees is that it's very risky to dock exempt employees' pay, just because once you start docking their pay, you do get into a lot of gray area and you can risk basically eliminating their exempt status if it begins to look like you're paying them based on the number of hours they're working. So for all employers, I would just say be very, very careful if you get into a situation where you think you want or are going to start docking exempt employees' pay. And I'd certainly advise you to consult with someone who has expertise in this area, just to make sure that you're dotting your I's and crossing your T's, because the last thing you want is to decide you're going to dock them for 3 hours of pay and then get hit with a wage claim for a lot more money than that.
Okay, so bottom line is don't dock exempt employee pay unless you have a really good reason and unless you've already spoken to someone about doing that. So, okay, and then the question about independent contractors, she followed up just to say she was looking for perspective on independent contractors being able to file for unemployment. So yes, they can. That is, even those sole proprietors now can apply. Okay, so we have one other question here. We normally have over 500 employees. However, we're a non-essential business, so we have had to temporarily lay off many. With that, we still have some employees remaining, but less than 500. So my question is, are those who are remaining at work, are they eligible for the Families First benefit? So maybe you were going to answer that along the way. But that's a great question. You were 500 and now you're not. So how does that all work?
I wasn't going to answer that specific question. But basically, the act applies to employers with fewer than 500 employees. So I would say that as of the date of the act effectiveness, which is today, if you have fewer than 500 employees, then yes, you are subject to the provisions of the act.
Cool.
Any other questions?
Nope, all good.
Okay, so let's talk a little bit about the emergency paid sick leave portion of this. Employers with fewer than 500 employees are required to comply. However, businesses with fewer than 50 employees are exempt from complying if providing paid sick leave would quote unquote jeopardize the validity of the business. Now, it's really important to note on this that when this bill was first passed, it seemed like this small business exemption was sort of applicable across the board. However, the Department of Labor guidance that has come out in the past week or so has made it clear that this exemption really is more narrow than it initially appeared to be. First and foremost, the employer has to meet certain requirements, and it applies only if the employer is seeking an exemption with respect to an employee who requests leave because his or her child's school or childcare, daycare is closed or unavailable. the small business exemption does not appear to apply if the employee is requesting or desiring to take paid sick leave for any other qualifying reason. So that's really important to note. I think that's probably one of the most important clarifications on the Department of Labor's FAQ page that's posted. Now, in general, in terms of eligibility and permissible uses for this emergency paid sick leave, employees can use this paid sick leave under any of the following circumstances, regardless of how long they've been employed. And I'm just going to read you the list of permissible uses. A, the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. B, the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. C, the employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. D, the employee is caring for an individual who is subject to a quarantine or isolation order who has been advised by a healthcare provider to self-quarantine. E, the employee is caring for a child whose school or place of care has been closed or whose child care provider is unavailable due to COVID-19 precautions. And again, that's where that small business exemption may come in. Or F, the employee is experiencing any other substantially similar conditions specified by the Secretary of Health and Human Services. Importantly, an employee cannot be required to use other forms of paid time off prior to being eligible for paid sick leave under the Act. And the employer can't require the employee to find coverage for his or her position or job duties as a condition of using this paid sick leave. There is an exemption from providing this paid sick leave for healthcare providers and first responders. With respect to the amount of leave that's owed, full-time employees are entitled to 80 hours of paid sick leave. Part-time employees are entitled to the number of hours equal to the number of hours that such employee works on average over a 2-week period. And if the employee is using sick leave for the employee's own care, then that paid sick leave has to be paid at the employee's normal wage rate times the number of hours that the employee would normally be scheduled to work. However, the pay is capped at $511 per day and a total of $5,110 in the aggregate. If the employee is using the paid sick leave to care for somebody else, then it has to be paid at 2/3 of the employee's normal wage rate times the number of hours that the employee would normally be scheduled to work. And this pay is capped at $200 per day or a total of $2,000 in the aggregate. Any unused paid sick leave under this federal act does not carry over from 1 year to the next, and it does not need to be paid out upon separation of employment. There are notice and posting requirements, and the poster that needs to be posted in a conspicuous place is available on the Department of Labor's website. The DOL's FAQs also specify that if you have employees working remotely, that you do need to send this notice via email or post it on your internal or external website where employees can go to find it. In terms of the interaction with California state or local sick leave laws, the new federal law specifies that it does not diminish the rights or benefits to which an employee is entitled under other laws. So the benefits available under this emergency federal legislation are in addition to whatever the employee would otherwise be entitled to under any California laws or any local laws. Now, with respect to tax credits, employers may obtain tax credits to ease the financial burden of providing this paid sick leave. The tax credit is applied against the employer's portion of Social Security taxes, and the credit is equal to 100% of the qualified sick leave wages, which again are capped at $511 per day or $200 per day if the employee is caring for somebody else. Because this new law is intended to just address this pandemic, this legislation is scheduled to sunset on December 31st, 2020, unless it's extended. But hopefully we won't be in crisis for that long.
I hope not. We have some questions here, Jenna, before you go farther. So one is, this is a great question. We have more than 500 employees. So do we need to display the poster? And I think really, does that mean this all applies to an organization with more than 500 employees?
So So this act does not apply to larger organizations with more than 500 employees. So you're technically not required to comply with any of its provisions.
Okay, so you don't need to send the poster out. The other question is there a California version of the notice? The answer, I think, is no. And also, if an employer already has sick leave benefit, do you have to provide the additional paid sick leave?
And on that third question, the answer is yes. It appears that these federal benefits are required to be paid in addition to whatever the employee is already entitled to under state or local ordinances.
So if I'm
Okay.
offering 5 days of sick leave, which is 40 hours, so now I have to add an additional 40 hours or an additional 80 hours?
It's my understanding that they would be entitled to up to an additional 80 hours.
Okay.
Yeah.
Good to know.
In terms of the interplay of this emergency paid sick leave with the emergency FMLA expansion, which I'm going to discuss in detail in a minute, a business employing fewer than 500 employees is required to pay this 80 hours of paid sick leave for a qualifying reason instead of leaving the first 10 days of expanded FMLA unpaid. And I'll discuss that more in a couple of minutes. But let's move on to this emergency FMLA expansion. In general, some of you smaller employers may not be familiar with the FMLA. In general, the normal FMLA, I'll call it, permits eligible employees of covered employers to take unpaid leave because of the employee's own serious health condition, or to care for a family member that has a serious health condition, or to bond with a new child entering the family. So this new federal legislation amends the existing FMLA to add an additional basis for taking this job protected leave, which is the COVID-19 crisis virus. Now, normally the FMLA only applies to employers with 50 or more employees, but this new expanded FMLA applies to employers with fewer than 500 employees. So same as with the emergency paid sick leave. Again, there's that exemption for smaller businesses, 50 or fewer employees, if providing the leave would jeopardize the viability of the business. Now, employees who have been employed by a covered employer for at least 30 days are eligible to take this expanded FMLA leave. In terms of the duration of the leave and the permissible uses, eligible employees can take up to 12 weeks of job protected leave if they are unable to work or telework due to the need to care for a child whose school or place of care has been closed and whose child care provider is unavailable due to the COVID-19 pandemic. With respect to compensation, the first 10 days of this expanded FMLA job protected leave can be unpaid. However, the employee can elect to substitute any accrued vacation or personal leave or sick leave for such unpaid leave. So going back to what I mentioned at the end of the paid sick leave section, if the employee qualifies for both the emergency federal paid sick leave as well as this emergency federal FMLA, they can opt to substitute that 80 hours of paid sick leave for the first 10 days of this unpaid FMLA leave. Or they can substitute other accrued but unused paid leave during this first 10 days, which is technically does not have to be paid. Now, the remaining 10 weeks of this leave has to be paid at 2/3 of the employee's regular rate of pay times the number of hours that the employee would otherwise normally be scheduled to work. But these qualified leave wages are capped at $200 per day for each employee and up to $10,000 per calendar quarter. In terms of the employee's right to be restored to their previous position, unless the employer has fewer than 25 employees, an employee taking this expanded FMLA leave generally has to be returned to an equivalent position upon returning from this leave. Employers that have fewer than 25 employees are generally excluded from this restoration requirement if the employee's position no longer exists following the emergency FMLA leave due to this economic downturn. But this exclusion is subject to the employer making reasonable attempts to return the employee to an equivalent position and requires the employer to make efforts to return the employee to work for up to a year following the employee's leave of absence. And again, this legislation is scheduled to sunset at the end of this year, and hopefully there won't be any need to extend it beyond 2020. As with the emergency paid sick leave, there are tax credits available. Employers are entitled to a tax credit equal to 100% of the qualified family leave wages paid under this act. Again, these credits are applied against the employer portion of Social Security, and these qualified family leave wages are capped at $200 per day or $10,000 per calendar quarter. So that's sort of a brief overview of these two big chunks of the emergency federal legislation. But do know that there are other resources that may apply to your organization or may be helpful to employees. There are state resources in California. We have, of course, unemployment. But employees may also be eligible for state disability benefits. They may be eligible for paid family leave benefits. There may be resources available to them on a local level if, either this federal law doesn't apply for whatever reason, or if they, need more support during this time.
We don't have any questions on everything you've said. There was a lot in there. I'm curious. Oh, here comes some questions. Okay, we are doing all that we can to keep employees working. However, their hours have been decreased. Most are on partial UI. My question is, if we find the need to lay off an employee, I lost my spot here. If we find the need to lay off employees in the upcoming weeks, can we lay them off still if they are on this Family First benefit?
Yes, they do not. Yes, you're entitled to lay them off. If you do lay them off, they are not entitled to continue receiving benefits under the act. They're going to need to turn to unemployment or these other state and local resources that I just mentioned.
Okay, and then the next question, just to recap, both Families First and FMLA apply only to COVID-19 related situations. Is that correct?
The emergency federal legislation on both the paid sick leave and the FMLA expansion apply only to these specific COVID-19 situations. The regular FMLA is still in effect for employers with 50 or more employees. So employers that are normally subject to the FMLA should continue to comply with sort of the normal FMLA provisions, in addition to these COVID-19 related expansions.
Okay, any other questions? All right.
So, if your business is going to be operational, I know, we've said there's a lot of information being thrown at all of us on a daily, hourly, minute by minute basis. But try to at least stay as up to date as possible with respect to other modifications and changes with respect to your obligations as an employer. Now, a lot of different sort of rules have been relaxed during this time. For example, the Department of Homeland Security has relaxed its rules for I-9 verifications for employers operating remotely. So employers who are operating remotely due to COVID-19 can now inspect their worker documents by remote means, meaning by video conference, by fax, or by email. And they can obtain, inspect, and retain copies of the documents as opposed to originals. Notably, this modification does only apply to employers who are operating remotely in response to the pandemic. And once normal operations resume, all employees who have been onboarded using this remote verification have to report to the employer within three business days to complete an in-person inspection of their original identity and employment authorization documents.
And I'll just throw in there, because I know some of my clients haven't done I-9s correctly in the past. The Department of Homeland Security has really increased its audits on I-9, especially in certain industries such as construction or hotels. And it doesn't mean anybody's that some of us are exempt. It just means they certainly have focused. But just while I have your attention, wanted to put out there, those I-9 verifications are super important. If you're not doing them correctly, you can find yourself in some serious trouble. So just wanted to throw that out there. As if you don't have enough to worry about.
Right. Well, I think, Katherine, I think that really goes back to what I was saying earlier, is that, it's such a tough time for employers because we're all trying to figure out, what all of this new stuff is, but we're also still required to comply with all of our old obligations, our existing obligations. So, to the extent possible, don't get so bogged down in trying to figure out all this new stuff that you're letting, you're slipping up with respect to the other stuff. Because like I said, unfortunately, this crisis really is sort of a boon for plaintiffs' attorneys who you can bet are going to capitalize on employer mistakes during this period.
And I've actually seen that as an HR consultant where there are just those ambulance chasing type of plaintiffs attorneys, and I know plenty. For example, Michelle Baker in our networking group, Jenna, she's a plaintiff's attorney and she's very reasonable. So if you had an unhappy employee who called her, she'd probably ask a lot of questions. And a lot of times she finds herself saying, well, why don't you go back to the employer and talk about these different things with them and then call me back if it doesn't work out, versus others who might say to your employee, well, the thing you're talking about probably doesn't have a claim attached to it, but let's talk about your wages and your lunches and how were they treating you during COVID. And so I've seen it personally where they just, those plaintiffs attorneys send out those letters, the demand letters, and you end up paying it because fighting it is going to be more expensive. So I'll just add too, going back to culture, that treating your employees with as much dignity as you can possibly muster with everything going on is going to be key. You want to keep your employees as happy and as high a spirits as you possibly can. And it's those employees who feel like their dignity was stripped from them. Those are the ones that go looking for a plaintiff's attorney. It's not really about what happened to them at work. It's about the way it was handled. And the only way to get their dignity back and gain control or get some power back is to sue. So I hate to say all that, and we're all anxious enough, but it's just so important that you're doing everything you need to do and really treating people with dignity.
Yep, great point.
I have one other question here. So we have less than 10 employees. If we reduce hours, do we need to register with a government agency so that the employees get the reduced benefit? And how do the employees apply for the reduced benefits or the reduced hours benefit?
I'm not sure what reduced hours benefits you're referring to specifically. If you're reducing their hours, then they are, at least in California, they're eligible to get unemployment. So they should be applying for unemployment. To my knowledge, the business itself doesn't need to do anything or register anywhere. I believe that when they fill out the unemployment application, they'll just have to note on there that their hours were reduced, and then the employer likely will have to verify that that is the case.
Actually, I was looking at this yesterday. It looks like there's basically two kinds of unemployment now. So if you lay an employee off and they're not coming back, and they're being let go, then they would kind of use the regular unemployment that we've always had. Versus if you're reducing their hours or putting them on furlough for a couple weeks and then you expect to hire them back, there is a different form for that. And you do have to fill out a section of it, kind of what Jen is saying, so that you can verify what's going on. So you can go to the EDD's website, if you're in California, and get both of that information easily. Excuse me, another question. If an essential employer, sorry, I have a frog in my throat. If an essential employer has an employee that doesn't want to come to work for fear of COVID-19, would she fall under the FMLA Act if she lives with an elderly grandparent who does not have signs of COVID? So you have an employee who's worried about bringing coronavirus home to the grandparent. How do you handle that?
So this federal FMLA expansion only applies to employees who are unable to work because their child care is unavailable. So it wouldn't apply to that specific situation where somebody is worried about bringing the virus home. So no, I don't think this emergency federal legislation is going to apply in that situation. I would say, as an employer, I would try to be as obviously understanding and flexible as possible. If this is a situation where the person can telework, certainly, I would try to make that work. If it's not possible for them to telework and they just don't want to come to work, I would say if they have accrued PTO or vacation time available, try to, if it's feasible for the business, allow them to use that and try to, see what you can do to come to some sort of arrangement that takes those concerns into account. But no, that's not a qualifying reason under this emergency federal legislation.
Okay, another question. What if an employee discloses that they're high risk due to asthma and wants to stay at home and use their sick leave and accrued vacation? Can the employer accommodate? Yeah, if they're using their own sick and accrued vacation. Well, Jenna, I'll let you answer.
Yeah, so I'd say that gets into like a little bit different territory, because if they have a condition and they are high risk, then they potentially qualify as somebody with a disability under California's Fair Employment and Housing Act. And just a general note, you are as an employer still required to comply with your obligations under the FEHA in California, or under the Federal Americans with Disabilities Act, in addition to all of this new federal stuff. So if somebody does have a disability and is entitled to a reasonable accommodation, certainly that reasonable accommodation could be working remotely, or it could be taking a leave of absence. Now, normally you don't have to, if the organization and the employee engage in the interactive process and determine that a leave of absence is the reasonable accommodation under the circumstances, the employer normally does not have to pay the employee for that time. But certainly if they do have, accrued but unused vacation or PTO, they should be allowed to use that if they choose.
So here's a little bit of a philosophical question. Does it hurt my employee if I pay out PTO now, versus having them use their unemployment? So I think it all depends on why they're not coming to work or what's happening. If they're afraid to come to work, but you're an essential employer and you're open and you need them to come to work, then you can say, hey, you can stay at home, but you've got to use your PTO for that. Versus unemployment is something that the employee gets if the organization is the one saying, we're letting you go or reducing your hours. So keeping in mind too that employees now have a lot more PTO to use or play with, unless you have that exemption. But PTO is, geared toward, if that's their choice, essentially, to stay at home, then they can use the PTO.
Well, and just, Katherine, to be clear on that, they only qualify for those 80 hours of paid sick leave if they fall into one of those specific 6 categories that I listed.
Good
so it's
point.
it's not an across the board, now everybody gets an additional hours of 80 hours of PTO. It's only if they fall into one of those 6 specific categories.
So I guess, so that maybe is the answer. If an employee comes to you and says, I'm afraid to come to work because I have a grandparent at home or because I have asthma or something, as Jenna said, the asthma situation is a little bit different because we're getting into more kind of ADA stuff. So if an employee just says, I don't want to come to work, I'm afraid to get coronavirus and bring it home to a family member, that's where you've got to have that dignified, respectful conversation about what's going to work for both of you. So you could say, well, you can stay at home and use your PTO. The other option is I can perhaps put you on furlough so that you can get unemployment, but maybe I need to lay you off and I'm not sure if I can get you back. So, but I think having those collaborative, let's make a plan together conversations is what's going to be important. And I've been very open with my employees about everything I'm trying to do to make sure they're still earning money. And I think that's, back to that transparency of just here, we're all in this together and let's all work together to make sure we all survive. The business survives and you survive and I survive. So.
Yep. All right. So we've got a couple more minutes. So just wrap up. So if you are having employees come to your work site because you're an essential business, you are obligated to maintain a healthy and safe work environment, at least to the extent possible under the current circumstances. So obviously you want to actively encourage sick employees to stay home. identify where and how workers might be exposed to the virus within your work environment, educate employees as to how they can reduce the spread of the virus while they're at work, establish policies and practices for social distancing. If you currently have some sort of office arrangement where people are sitting within a couple of feet of each other, you may need to rearrange your office so that people have more space between them. Practice routine environmental cleaning. And there's a ton of guidance and resources on both OSHA and the CDC's website. So I'd encourage everyone who does have employees working at the work site to check out those resources and do what they can to, make sure they're compliant with the guidelines and try to reduce the spread of this thing.
All right, I'm getting a couple questions, so I'm gonna, so one person says, just so I'm clear, the FMLA Expansion Act applies to employers with 500 employees or more with regards to child care only, or nothing in the Expansion Act applies to employers with 500 or more?
Nothing in the Expansion Act applies to employers with 500 employees or more. Both the emergency paid sick leave provisions as well as the expanded FMLA only apply to employers with fewer than 500 employees.
Another question, once rehiring resumes, do the furloughed employees have priority over the laid off employees?
So I guess I'm not entirely clear on how the distinction between furloughed and laid off is being used. As I was kind of discussing in connection with the pay issues, for all intents and purposes, at least in California, your furloughed employees who are being furloughed for, more than a week or two are kind of considered laid off under California law. So it's sort of a distinction without a difference. I don't know how the person asking the question is trying to distinguish the two, but I'm not aware of any specific guidelines or guidance in terms of who gets rehired. I think that's going to be a very case-by-case basis depending on, the operations and the needs of each business.
So it sounds like, so in principle, a furloughed employee is one that you've said, we don't have hours for you, but we expect you to come back, and laid off is more of the final, we're letting you go and
Right.
you're not coming back. So so Jenna, it sounds like you're saying there isn't any rules around that really in the law. There is no distinction. And so it would really kind of be up to you. I would suspect if you furloughed someone, it was because you wanted them there when this was all over versus laying someone off. All right, so I wanted to talk a little bit more about some kind of culture stuff, and then we'll just open it up and free for all with any other questions that you might have. I know we're all anxious, and I don't want to put salt in the wound, but just wanted to remind you that you're anxious about your business, but your employees are anxious about all of the other same things that you're anxious about as well. So we're all concerned about safety. Change is stressful for everyone. Most people don't do well in change, and we've just all had to turn on a dime. The entire world is turned on a dime. Disruption is anxiety, full of anxiety. We're worried about our clients. We're worried about our work. Your employees are worried about staying in your, visions or peripheral vision so that you're not laying them off, or that they still remain important in your eyes. So they're worried about that. We're all worried about what's going to happen to our economics, right? How are we all going to survive this when the economy continues to downturn and we're not really sure how long it's going to last? So we're all concerned about a lot of things. And so what I've been thinking about is, how do I pull from my life as an organizational development consultant, and as somebody who's focused on culture change, that means I'm working with clients around change all of the time. And so I wanted to just give you some tips about what I know about leading employees through change, because that's what we're all doing right now. We're all leading people through change. So there are these four sort of phases of organizational development change, and they apply here. And the idea is that as people go through change, we all start off in sort of comfort and control, that even in a toxic environment, for example, where I'm going, even though it feels toxic, there's some level of comfort in knowing that the same thing's going to happen every day. There's some, control that they have over it. And what change does is make people wonder, where do I fit into this change? And as humans, we need control. And in order to survive, it's a survival instinct to have control. So all of a sudden, through organizational development change or culture change, we're pushing on people's comfort and control, and they move into this phase of fear, anger, and resistance. Well, that's where all of your people are right now. People were comfortable, and now all of a sudden the entire world has been thrown into fear, anger, and resistance. And there's a lot of research on what you need to be doing when people are in this phase of change. And it's really about collaboration. That's the key word here. So talking about the future together. And hey, you may not know what the future is. We barely know what tomorrow is going to look like. As Jenna said, the laws are changing constantly, or guidelines are being published constantly. I don't know if my big client's going to cancel tomorrow because they're out of money. Who the heck knows? But to the best of your ability, talk about the future and what it looks like and what you expect to have happen and what your goals for the future are. So define the future as much as you can. And then really listen to what people are afraid of. What are your employees afraid of? What do they need from you? What's their future look like? What do they think the goals of your organization should be? So again, really just about collaboration, being super transparent about everything you do know, and being transparent when you don't know. If they're asking you what's up with this client, are they still going to be our client next month? It's okay to say, you know what, I don't know. I've talked to them about it and they don't have an answer, so I don't have an answer. And also, don't try to talk people out of their feelings. So if someone comes to you and says, I'm really anxious about all of this, you should not say, well, don't worry about it, we'll get through it. You have to validate their feelings and listen and talk through it. So this fear, anger, and resistance phase that everybody is in, as a leader, you've really got to focus on collaborating about the future and talking about the now and just open communication. The third phase of change is experimentation. And so what happens is, as when I'm doing my culture consulting, what happens is, as people kind of get over their fear, anger, and resistance to change, they start experimenting with the new way of doing things, right? So just as an example, perhaps we're updating the performance management system and there's anger and resistance for that updated system. People feel like, well, it worked before, why are we changing it? But as they start to get over that, they start saying, okay, well, maybe I'll try it. I'll try these new questions that I've been asked to use, or I'll try this new form I've been asked to use. And so same for right now with COVID, your people are probably also experimenting, right? All of a sudden they're working remotely, for example. So they've been thrust into experimenting with remote work. And so some key things that you've got to be doing in this phase. So what you've got people in probably both of these phases all at the same time, is to give people direction and information, but also empower them to do their thing, right? So in terms of working remote, for example, you're going to set guidelines about how that's going to work, but then you have to let them feel free to function in their own way. Giving people permission to seek out their own solutions so that they're not constantly coming to you for solution. Give them freedom to make decisions. You have to encourage some risk there, right? And obviously within reason, but there is risk to doing things in a new way. So give people permission to take risks and make mistakes also. So then we're back to collaboration on this as well. So I wanted to share this with you. This is what I know about leading people through change, and it's what I'm striving for right now as the leader in my organization. So hopefully those are some good tips for you. Really and truly, you've got to communicate as often as you possibly can. Communicating daily about what's happening, definitely calling every single one of your customers to ask them how they're doing, what do they need from you, how can you help them. We've got a little kind of e-newsletter that we're sending out specifically for our HR clients, to kind of give them updates and let them know that we're here for them. Just staying in touch with your community. So East County Chamber, I know a lot of you are on today. Reach out to each other, have virtual happy hours with a few of you, or maybe the chamber would even do a big happy hour, but just making sure that you're staying connected with your network. Some things to consider when you're emailing folks, and I've haven't seen as much of it now, but at the beginning of all of this, everybody was in high stress, and I was getting emails from different vendors, as I'm sure you are as well, where people were saying, the world is ending. Here are the resources we have for you. Ironically, one of my clients, their employee assistance program sent out an email. Luckily, they only sent it to our office coordinator at this client versus to everyone. But the office coordinator gets this email that's from the EAP that's like, your employees are in high stress right now. This is out what was it, like an outbreak and a big disease, and they need to survive. And it was just using all of these emotionally charged words, and the point was, if your employees are feeling anxious, let them know that they can call us. We're the EAP. And I just was like, wow, that's ironic. This email is full of anxiety ridden words and emotionally charged phrases. So that has really stuck with me as I've been communicating and really trying to, and hopefully I'm doing that for those of you who get my e-newsletter, trying to stay more positive and sort of calm versus the world is ending. So just, everybody's already anxious, so let's not increase that. I've got a comment here. Leadership East County is working on a social hour with program participants for next week. And let Nick know, my husband, he's on the leadership group. So that's great. That's what we should be doing, right? Um, so if layoffs are something you're thinking about, just some different ways to consider preserving cash. One is to reduce hours, which might be better than laying people off. Perhaps you ask people to reduce their pay. So one of my girlfriends, she told me that at her workplace, and I thought this was pretty cool. They put people in tiers. So if you're making less than 50,000 a year, your pay cut is 10%. If you're making between 50 and something like 200, then your pay cut was 30%. And then if you're 200 and above, your pay cut was 40% or something like that. So they were cutting dependent on where you were. Somebody who makes 50 grand probably can't withstand a 50% or 40% pay cut, but that might be a way to go about it. And then certainly eliminating any bonus programs. If you're offering commission, might be a time to have a conversation about, hey, we just can't pay this out right now. Obviously, you'd want to speak to an attorney before you do something like that, because commissions are part of pay. But just get creative with how you preserve cash. Again, everybody's anxious right now, and so you've got to make things predictable. And right now, everybody's got to be focused on resilience. And resilience is about adapting well in adversity and bouncing back from adversity. And there is a lot of research on resilience. And I have a special interest in this topic as a business owner, and all of you, or those of you who are business owners, probably have some similar interests. We have to be resilient as business owners. There are 4 key things that resilient people do. They make and execute a plan. Every single morning, I figure out exactly what I'm going to do that day, and I do it. And then the next morning, same process. And I also have my long-term sort of 90-day plan. What do I need to do in the next 90 days to be resilient and get through this? Building connection, having those virtual happy hours, having those virtual meetings. Of course, you've got to remain positive. Stay away from the news. You don't need to be on the news every hour of every day. It's going to get to you. And really take care of you. Use this as an option or a time to do some self-discovery. What kind of a person are you when there's a crisis? Are you the kind of person who runs around with your head cut off, or like your head's cut off, or do you stay calm and make a plan and execute and pull yourself through it? So do some self-discovery. And lastly, as your culture consultant, I've got to tell you, you have to use your core values to guide you through all of this. These are Civility Partners' core values, and I can tell you, I certainly have to live a warrior spirit right now. I am learning a ton day in and day out. I'm trying to treat people the way I want to be treated. I'm being authentic and legitimate, and we all have to be extraordinary right now. So whatever your core values are, make sure that you're using them to guide you. Lastly, I know we're sort of out of time here. So Jenna, I'm going to skip over to this slide so you can speak to the resources a little bit. And I wanted to offer up something, and Jenna has something to offer up as well. So give us a couple more minutes here of your time, and then we'll close out the webinar.
Yeah, so I mean, my last point was, easier said than done, but try not to panic. I mean, they are unprecedented times, but that doesn't mean that it is the end of the world. There are lots of resources out there, some of which we discussed today, but there are lots of other things that are out there for employees, for individuals, for businesses, to help you get through this difficult time. I'm sure all of you know that the state and federal tax filing deadlines have been extended to July. There are small business administration loans available with very low interest rates. The federal stimulus package, the CARES Act that was just passed, has various provisions that provide direct payment to individuals, augment unemployment insurance, delay payroll tax payments, provide relief for mortgage payments, rent payments, student loan debt payments, and have some various other helpful provisions for individuals and businesses. And like I've said a couple times, there are a lot of state and local resources out there as well. If you just do kind of a Google search of your locality and COVID and resources, you will probably hit on tons of websites offering up different places that you as an individual or your employees as individuals or your business can go to get some help. So, like Katherine said, we all are in this together and we will all get through this together.
Yep. So what we're offering is these 3 items. So one is we have a template pandemic response plan that we put together. It's a little late in that a lot of it is, you should have a response plan before something like this happens. But there are some chunks in that template that would be pretty useful for you now. For example, how do you lay out who's doing essential work versus the employees that you could lay off, and how do you adjust people's work so that you can still function as a business. So shoot us an email if you want that. I'm also starting some weekly, what I'm calling mastermind group meetings. These are free. It's just, I thought I can read all sorts of stuff online about what I should be doing as a business owner, but it might be nice to speak to other business owners and HR professionals and leaders and consultants about what they're doing as well. So if you're interested in just having some Zoom calls with other people and you want to find out what they're doing, maybe you have a question about something that you need to solve, let us know and we'll send you the registration link for that. It's free, and I think we're going to do it every week. The first one is on Friday. And then of course I'm going to continue to try to give out webinars and resources on things that I feel you might need. So shoot us an email if you want that. And here is both Jenna's and my contact information, and Jenna is offering 20% off of her hourly rate if you attended the webinar. So if you have more questions for her, you feel like you need some real legal advice, she's offering a discount just to in the interest of making sure everybody gets what they need. I know we're essentially out of time, but is there any sort of one last question that was burning that somebody needed to have answered before we pop off? You guys had a lot of good questions all throughout, so I didn't think we'd make it all the way to 90 minutes, but we sure did. All right, I don't see anything else coming through, so shoot either of us an email if you need something, and we're all in this together, so we'll try to get you what you need. And thanks, Jenna, for joining me today on this.
Thank you, and thank everyone for your participation and good questions.
Yes, we're sending out a webinar recording, not to worry.